versus Dabai, where Okoro Jesse, as he then was said, when a petitioner is alleging that the respondent was not elected by majority of lawful votes, he ought to plead and prove the votes cast at the various polling stations, the votes illegally accredited to the winner, and the votes which ought to have been deducted from the supposed winner in order to see if it will affect the result of the election. Where this is not done, it will be difficult for the court to address the issue. See Awolo and Shagari, close of court. See also Ojo versus Isohe and others, Taba Jesse as he then was. The averments of petitioners in paragraph 107 of petition only showed the votes declared by ANEC, which the petitioners are disputing as manipulated. Nowhere in the petition did petitioners plead that what they considered the authentic votes of the election to guide the court in the inquiry suggested by them in this allegation. The second respondent did not poll majority of lawful votes in the election. Their petition therefore did not meet the legal threshold to ignite a proper inquiry by this court, and so lame even on the pleadings. Going further, if we must at all, the petition claim is that 19,702 polling units results contains various forms of infractions. They assert that results from a total of 4,307 polling units are without stamp on the respective forms EC8A from the states, and details are said to be in the statistician's report, which report we have repeatedly held incompetent and inadmissible. They also contended that results from 1,300 polling units do not have signatures of the presiding officers on the respective forms EC8A. It was also alleged that results from 6,408 polling units have and indicate zero accreditation. It was further alleged that 9,464 polling units across 30 states showed that the votes returned are in excess of accredited voters. Furthermore, that the presiding officers failed to properly fill and countersign alterations in election forms, including forms EC8A, EC8B, EC8C, and EC8D in over 40,000 polling units, which they claimed were in the statistician's report. It is clear from the averments in the petition as captured above that neither the particulars of the polling units in issue nor those involved in the irregularities were given by the petitioners. In any case, our law is well settled that before a party can legally rely on fraud or forgery or any form of malpractice as alleged in this petition, the facts must not only be pleaded but particulars thereof must be provided in the pleadings. The petitioners in the pleadings from paragraphs 128 to 142 avert to issues of violence and disruptive activities. These allegations are criminal in nature. The standard of proof where an allegation of crime is made in an election petition is proved beyond reasonable doubt and not on the balance of probabilities. See Emmanuel and Umana. A complaint of massive suppression, deduction, and allocation of votes connotes forgery or fraud, particulars of which must be pleaded and proved beyond reasonable doubt. See Kaki and PDP and others, Ngobodo versus Ono. First, respondent joined issues with the petitioners' allegations in paragraphs 92 to 142 of the petition. The second respondent and the third respondents in a similar manner joined issues with the petitioners in calling on them to prove their claims as required by law. What this entails is that the petitioners who made all these allegations have the burden to prove all the allegations as required by law. The petitioners have placed reliance on the evidence of their statistician and forensic expert, who are PW21 and PW26 respectively. Had time to look at the evidence of these witnesses and had ruled that their evidence, apart from being improperly before the court, is also hearsay. The statistician's report rolled out figures or forms which he claimed were either not signed or stamped, but none of the forms referred to was attached to the report. The polling unit agents of the petitioners who were present in all the polling units around the country were not called to testify to any problem or difficulties in their polling units on the 25th day of February 2023 presidential election. That is fatal to the petitioner's case. Thus, in Belgore versus Ahmed, it was said by Taba JSC as follows in the lead judgment. With respect to the volume of documentary evidence, I wish to state at the risk of repetition that they were merely tendered across the bar by Land Council for the petitioners at the trial. He did not and was not in a position to answer questions or otherwise speak on any of them. Their makers were not called. In such circumstance, was the trial tribunal bound to ascribe probative value to them? I shall answer this question in the negative. The trial tribunal had no duty to accord probative value to the mass of documents, their status as certified documents notwithstanding. There is no doubt that the petitioner's decision to tender the mass of documentary evidence at the trial was prompted by the urgency dictated by Section 2856 of the 1999 Constitution as amended. That, however, does not diminish the petitioner/appellant's burden and standard of proof of the petition. They had a duty to prove their petition according to law, close of court. This position of the law may have been fairly watered down under the current electoral regime by Section 137 of the Electoral Act 2022, stating that it shall not be necessary for a party who alleges non-compliance with the provisions of this Act for the conduct of elections to call oral evidence if originals or certified true copies manifestly disclose the non-compliance alleged. But even at that, it cannot be gainsaid that oral evidence is necessary to explain discrepancies in original or certified true copies of election documents, where the complaint verges on whether an alteration or amendment in an original or certified true copy of a polling unit result was made with intent to falsifying it, or whether it was simply made to correct an apparent human error in the course of making entries in the result. Such situation would surely need a witness to explain or speak to the documents in order to prove falsification of election documents when it is so alleged.